Overview of legal framework. The legal framework for public education. All three units of government, federal, state, and local, exercise some degree of authority and control over U.S. public education. Educational governance of public schools is the result of constitutional and statutory provisions of the federal government, the 50 state governments, and case law. The degree of authority and control that local school boards have over school operations depends on the constitutional and statutory provisions of their state. In the state of Alabama, there are 138 different school districts. The state requires each district to have a local school board of education to provide supervision of local policies. The School Board of Education is the connecting piece between school and state, as well as between the citizens and the school. In the local government, the school board responsibilities include representing the local community in school goals and values, create public policy, school policies, rules, and regulations, responsibility to ensure that policy is implemented, starting with the superintendent. In the local government, community connection is important. The local school board of education is the connection between the local citizens and the school. It keeps the community informed about school decisions. It wants what is best for its community: staffing, educational objectives, and financial decisions. School board policy is important in the local government. The policies are intended to be broad statements that connect to state law. They should be used as a framework to make decisions, but not a step-by-step procedure. Policies should be written in a way to provide flexibility when needed. They do not create legal right, and all policies have to be made available to the state superintendent of education. The state role in education includes the federal authority is restrictive concerning education. The state has complete authority to provide a public education system. State-level sources of law include the state's constitution, state administrative agencies, and case law. Public education is left to the states to control. State constitutions represent the basic source of law for individual states. Generally, the legislative bodies are required to make provisions for a system of free public schools. State constitutions also restrict the powers legislative bodies may exercise. State courts are often asked to interpret issues in an educational context. State statutes. Public schools are governed by state statutes enacted by state legislatures. State statutes represent an important source of law for school administrators. State statutes that govern the operation of public schools vary state to state and from subject to subject. A few things governed through state statutes is to raise revenue and distribute educational funds, establish the school day, length, and year, establish performance standards, set rules for suspension and expulsion, create, alter, and abolish school districts and boards. State agencies typically include a state board of education, a chief state school officer, and a state department of education. The function of state agencies vary state to state. A state department of education typically contains divisions for specialized services such as administration, finance, instruction, and research. Case law. State court decisions provide another source of law for school administrators when there is no policy direction from the state constitution, state statutes, or state administrative agencies. A decision of one of state's highest court order is not binding in another state, but such a decision does provide school administrators with the rationale of another state's highest court in an area of concern. Unless a federal issue is involved, there is no appeal of a decision of a state's highest court. Federal. The United States Constitution, federal statutes, federal administrative agencies, and case law all constitute sources of law under which school administrators operate. Education is not specifically mentioned in the Constitution. Federal law covers 7% of the total expenditures. And federal is a very pervasive force. Federal Constitution equals supreme law of the land. All statutes passed by Congress, state constitutions, and statutes and policies of local school boards are subject to the provisions of the U.S. Constitution. The provisions of the Constitution that have had the greatest impact on the operation of public schools are the General Welfare Clause, 1st, 4th, 5th, 9th, and 14th Amendments. The First Amendment covers the freedom of speech portion, which has evoked numerous court cases involving students' and teachers' rights to freedom of expression. The Fourth Amendment is the right of the people to be secure against unreasonable searches and seizures, and no warrant shall issue but upon probable cause. The Fifth Amendment, no person shall be compelled in any criminal case to be a witness against himself, nor deprived of life, liberty, or property, without due process of law. The Ninth Amendment was brought forth in educational litigation in which teachers have asserted that their right to personal privacy outside the classroom is protected as a right. The 14th Amendment is the most widely invoked constitutional provision in school litigation, since it specifically addresses state action. No state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The General Welfare Clause, the Congress shall have no power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide the common defense and general welfare of the United States. The federal administrative agencies, the primary function of the Department of Education is to coordinate federal involvement in education. Case law, federal courts have contributed a significant body of case law, which has impacted educational policies governing the operation of public schools.